Welcome. I hope you'll excuse the slight lateness. In a way, it fits with this conference because the topic of this conference and a similar conference should have taken place probably 30 years ago. So we are not too late here with 5 minutes. Why this conference on the legal dimensions of Armenian-Turkish relations? Well, the first reason is very simple. These are events or treaties that have shaped the crucial period 1914-1923. They have shaped the future of Soviet Armenia, its borders in particular. They have shaped Armenian-Turkish relations in the 20th century. And today they are still shaping those relations with the revival of the issue of the Armenian-Turkish protocols, which implicitly impose recognition of the Treaty of Kars. This having been said, the real reason for this conference is that for many years I have been thinking about an expression that has been naturalized since the 1970s. That expression is Haitad, or Armenian cause. It appeared more or less in the 1970s, and it has been used since then, but as it often happens, the precise content of that expression is a little bit vague. Having been trained in France for 4 years in philosophy, I said, you know, when things look natural, maybe you do want to analyze them and see exactly what they mean. I was lucky enough to meet people belonging to the Western Armenian National Congress, and after a couple of discussions, it turned out they were also interested in such an event, and they have co-sponsored this conference. I am extremely grateful to them. If I may introduce them, we have here Dr. Karen Mikhaelian, Dr. Suren Seraydarian, and General Norat Tergrigorians. General Tergrigorians was the number 2 of the land forces of the Soviet army in the late Soviet period. I would like also to thank the Armenian National Committee, which provided money for the videotaping. And last, but certainly not least, I would like to thank the many students who came on a Sunday morning early on to carry coffee, set up the tables, arrange the chairs. I am extremely grateful to them for doing so at a time when usually on Sunday morning most students like to sleep a little bit longer than usual. I owe also a lot of things to a lot of individuals, and it would be ungratefulness not to thank Mr. and Mrs. Giray Mouramian, who took the time to come and help me take the participants to this conference to San Francisco yesterday afternoon. I would like to invite Dr. Seraydarian to say a few words in the name of his organizations, and then I will introduce the first speaker.
My late father used to say, when you speak, make sure that it is short and make sure that you don't take the floor in the afternoon after lunch. Well, first of all, let me give you an idea who is this funny animal that you see on the poster called Western Armenian National Congress. Actually, it's the Congress of Western Armenians rather than the National Congress of the Western Armenians. Anyway, the Western Armenians, who are the descendants, when we speak about Western Armenians, we are talking about the descendants of the survivors of the genocide and deportation, citizens of the Ottoman Empire. These citizens of the Ottoman Empire are, in our view, the legitimate claimants of their rights, not the Republic of Armenia. The Republic of Armenia is a sovereign, independent, and member state of the United Nations, of the international community. And has its own prerogatives and has to request to geopolitical, economic, social, and good neighborhood imperatives. An organized representative body of Western Armenians, a nation forced away from their lands. Look at the Rights of the Nations Manifesto of 1976, will earn the international right to represent itself. It will also be beneficial to the motherland as well as Artsakh, and it will be able to facilitate most of their dilemmas. Why Western Armenians and not the diaspora? Because people mix also the issue of diaspora and Western Armenians. Because hundreds of thousands of descendants of the victims of the genocide live in Armenia, and over 2 million in Russia, which in Soviet time they used to call them the internal diaspora. They have their own compatriotic associations, or as they say in Armenian, Hayrenakhtsagan Mutunes. The term is used to identify the Armenians who lived throughout the Ottoman Empire, from Constantinople to Van and Aleppo, from Cilicia to Trabzon and Edirne in Kars, to Kars. Now, in order to organize the Western Armenians, there is a need to create institutional and representational capacity to address all the issues of the legitimate violated rights. Hence, a group of some 40 historians, lawyers, businessmen, intellectuals from France, Armenia, Russia, Syria, Lebanon, USA, Austria, Canada, and Iran, established in 2007 an NGO called the International Organizing Committee, registered under French law des associations, to prepare a congress or a convention of Western Armenians. The organizing committee held 12 sessions, as well as scientific seminars in France, Switzerland, Cyprus, and Armenia. Some of the participants already participated in some of the seminars, like Professor Zayas. Now, there were 3 publications were printed and distributed. The first reflected without any comments, without any additional text, all the inter-Armenian talks and negotiations between 1913 and 1921. The second publication, was a summary of the Cyprus seminar, dealing with the main issues of Armenian claims, and last but not least, the book of Professor Vahan Melikian, which is Հայկական բանջարություն արևմտահայերի երրորդ համակումարի անհրաժեշտությունը. It means the Armenian claims and the necessity of holding a conference, a congress of the Western Armenians, of a third congress. Why third congress? Because 2 such congresses took place in Yerevan in 1917 and in 1919 to deal with the refugees and to represent the Armenian demands to the Paris Peace Conference, also to the Sevres Peace Conference. They failed, among others, because of disagreements between Bogos Nubar Pasha and the Haronian, and the insistence of one political party taking over the power in what remained of Tsarist Russian Armenia. The International Organizing Committee is now ready to call for the Congress, and it will be held this year on the 10th of December in Paris, in Sevres. So as soon as the Congress is established, the committee will dissolve itself, and our preparatory work will be considered completed. The board, a board will be elected in that committee, an executive committee if you want, to deal with the official entities, national courts, regional and international tribunals, NGOs, international and regional organizations, lobby groups, and why not Turkish intellectuals and lawyers convinced of the need to overcome their history and recognize the fact of what at one point in time we called the Mediterranean or genocide. And of course, the Council will have to address all the issues related to the territorial and property claims, private and public, the unlawful deportation of citizens from their original place of birth or residence, making them stateless, human rights deprivations upon past and current violation of human rights. The representative bodies should also prepare and eventually participate in any dispute resolution mechanism, such as arbitration, which may be instituted to achieve the above-mentioned goals. It has to ensure to the Executive Council that the Armenian cultural heritage is safeguarded by the Turkish authorities in accordance with the provisions of Appendix 4.1 of the Treaty of Lausanne concerning protection of minorities. And of course, establish, maintain, and contacts with all Armenian communities, as well as the Republic of Armenia, to ensure complementarity. We will continue to organize or co-sponsor seminars and symposiums such as this one in order to define where we are, where we stand, where we are going, and to make sure that we don't fall into the trap which the Chinese proverb answers, which says, when you don't know where you are going, you may end up where you don't want to be. Finally, I would like to thank particularly the participants, of course, in the first phase, all those who are present, but I have to stress the importance of the role played by Professor Astourian and as Executive Director of the Armenian Studies Program and the Institute, of course, of Slavic, Eastern European, and Eurasian Studies of the University of California in Berkeley. Once again, Mr. Astourian, thank you very much for taking the initiative, and I hope it will not be the first and the last time, but only the beginning of a long cooperation. Thank you. I hope I was not too long.
Thanks. The Armenian Studies Program has organized many events with the co-sponsorship of about every Armenian organization, and this is an excellent way for us to maximize our limited resources here, while preserving the purely academic nature of these events. Now, for me, it's a real pleasure to introduce Dr. Susan Karamanian, who took the time to come here yesterday evening, and she's going to leave immediately, very early after her talk today. And I really appreciate her not leaving, but coming for such a short time to give us a talk on the Treaty of Sèvres, making sense of Sèvres, an international legal perspective. Susan Karamanian is the Associate Dean for International and Comparative Legal Studies at the George Washington University Law School. Before joining the law school in 2000, she was a partner at Locke, Lord, Bissell and Liddell, LLP, in Dallas, Texas, where she represented foreign and domestic clients in a variety of commercial disputes. She has held various leadership positions in the American Society of International Law, is the immediate past president of the Washington Foreign Law Society, and she serves on the boards of the Center for American and International Law, where she is also a research fellow. She is a member of the Council on Foreign Relations and the American Council on Germany, and a fellow of the American Bar Foundation and the Texas Bar Foundations. She was a director of English studies at the Hague Academy of International Law. Dr. Karamanian graduated from the University of Texas Law School, Oxford University also, where she was a Rhodes Scholar. Welcome and thank you for coming.
Thank you. Thank you very much, Dr. Astourian. Good morning. It's an honor to be here this morning. I would like to thank Dr. Astourian and the Armenian Study Program, as well as the Institute of Slavic, East European, and Eurasian Studies here at the University of California, Berkeley. And also I'd like to thank Dr. Sardellian for the support his organization has provided for this conference today. As you heard, the conference is titled The Present and the Past, Legal Dimensions of Armenian-Turkish Relations. This is a very important and timely topic, timely in the sense of the developments in 2009 concerning the Armenia-Turkey protocols, but also timely in the sense that as I have been following the literature in the last 3 to 4 to 5 years, an increased focus on attempts by Armenia to address past wrongs through legal channels, and in particular statements being made that there needs to be a case brought before the International Court of Justice, there needs to be a case brought before the International Criminal Court in The Hague, or sometimes people will say, bring it to some specialty criminal court. I'm concerned about these statements because I don't think that the statements reflect accurately the proposed remedies that could exist if violations were established, given the limited jurisdiction of these courts, and also given the past conduct of the various parties, and of course the critical issue, as you just heard, about the fact that the people who and property related to the Armenians are largely in Turkey, yet that group doesn't really have an independent legal standing. We have, of course, a very strong Turkey in the region. It's attempting to reestablish itself not only in Europe, as I'm sure you're aware, but also throughout the Middle East. A very important development just in the last few years. And so, from my perspective, it is critical that these views be analyzed from the international legal perspective, and that we have a strong and correct understanding of what the law tells us with regard to potential rights. And in particular, I like to think of it in terms of the international law could temper some of the rhetoric. It is this law that ultimately should guide the conduct of individuals and states, both with respect to statements that are being made as well as to actual physical steps that could be taken. And it is this law that I will focus on today. The law is not a panacea. The law is fairly well developed. I think that it's important that we understand that the law could close some doors. It should at least put an end to some of the rhetoric, yet it could open the doors in other respects. And in this regard, I think factual developments are very important. Let me just lay some of the history out. We have noted historians in this room. I'm a lawyer, and so I'm sure there are some historians who have even more information than I have. But we have a diverse audience here. Some may have some of the background, some may not. So I think it's very important that we just at least get some of the history and the critical treaties identified, and then from there I will work through the analysis. In 1920, August of 1920, the Treaty of Sèvres was signed. It was signed by the Ottoman Empire, by the Allied powers, by associated Allied powers, including what was then the Republic of Armenian Republic. The treaty recognized various frontiers for Turkey. As to the frontier with Armenia and Turkey, it was recognized that the nations, that there would be an arbitration of that frontier with President Woodrow Wilson conducting the arbitration. The defeated Ottoman Empire had signed the treaty, as I indicated earlier, and in that treaty it recognized that Armenia, it acknowledged a separate Armenian republic. The United States was not a party to this treaty at this point in our country's history. We were having a bit of an isolationism challenges. Of course, we were having to deal with issues in Europe, but the United States kept a distance from what was going on in Turkey, although the United States and the Allied powers had recognized Armenia. The Ottoman Empire at this time was in a state of flux. The Sultan signed the treaty, but already Ataturk and his nationalism were on the rise in Turkey, and we were seeing the influence of the Russian Bolsheviks. The Allied powers and the associated Allied powers, even at the time of the treaty and after the signing of the treaty, were not harmonized in their views. And actually, if you look at some of the important historical papers, even within nations, such as in Great Britain or within France, there was dissension as to how to proceed after the treaty was signed. Now, the key provisions of the treaty, I'll just outline them. The treaty is quite substantial. I have it. I brought it with me. The beauty of this day and age is you can pick up treaties very quickly on the internet and get official copies, the official copy of the treaty. It's a substantial document. It establishes Turkey's frontiers with Europe and Asia, and to the extent that there were differences or difficulties, it recognized that boundary commissions would be established to address the details. Similarly with the Straits, an acknowledgement of passage through the Straits, boundary commissions to deal with the details. Then after the frontier issues are described, there is a series called political clauses. And in the political clauses is a separate section that deals with Armenia. Turkey, quote unquote, in accordance with the action already taken by the Allied powers, and you could also add, and the United States, end quote, okay, recognized Armenia as, quote, a free and independent state, end quote. So a formal recognition by Turkey of Armenia as a free and independent state, confirming that the Allied powers had already given that important recognition. Secondly, Turkey, Armenia, and the other parties to the treaty agreed to submit to arbitration before President Wilson questions concerning certain land rights and territory. And let me just specifically read the key language to you. That the frontier to be fixed between Turkey and Armenia in the vilayets of Erzurum, Trebizond, Van, and Bitlis, and to accept his decision thereon. So to have the frontier to be fixed between Turkey and Armenia in the 4 vilayets, and to accept the decision thereon, as well as any stipulations he may prescribe as to access for Armenia to the sea, so recognition that a landlocked Armenia would have very difficulty, and as to the demilitarization of any portion of Turkish territory adjacent to the said frontier. A recognition that there may need to be some type of structure put in place for security of the Armenia with the Turkish territory adjacent to the Armenian territory. And we're talking about Eastern Turkey now, and there was then a recognition in the treaty also that Turkey would renounce title to this land upon the date President Wilson issued his decision. There are other aspects of the political clauses that deal with Azerbaijan and Georgia, not establishing a border, recognizing that the parties would enter into an agreement regarding it, and a separate penalty section, the penalty section dealing with war crimes and massacres that had occurred on the Turkish territory, the obligation of Turkey to hand over to the Allied powers, particularly those who had engaged in massacres, the expectation that there would be an international tribunal or an Allied powers tribunal set up to try those individuals. The boundary commissions I mentioned, I have not been able to find if they were ever constituted. The penalties and these trials, there were some internal trials in Turkey. There were some Turkish individuals who were held in custody in Malta under the authority of Great Britain, yet they were never brought to trial, and they were subsequently released under an exchange. But most importantly, there was a lack of performance under the treaty as contemplated, but there was not a ratification of the treaty. The treaty specifically sets out that it comes into effect based upon the ratification, and it sets out the means for ratifying the treaty. And there was not a single ratification by any party to this treaty. There's a wonderful paper that a professor from the University of Ankara has written about looking at the British and Home Office papers going into the Foreign Affairs Office of Britain and finding that immediately after the treaty was signed, that British diplomats had urged the Sultan to go to the Turkish legislature and get it ratified, Britain not wanting to start the ratification process first, expecting that Turkey would take the lead, it would bear a lot of these obligations, and the Sultan immediately signaling that I don't think I have the political authority to do this. Perhaps very early after the treaty was signed, an understanding, at least by Britain, in the files, in the papers there, that they were not going to have a ratified treaty. That's important because of something I'll talk about in just a few minutes. The treaty also provided for dispute resolution. It incorporated, at the beginning of the treaty, the Covenant on the League of Nations. And that covenant provided for resolution of disputes through arbitration, disputes concerning international law and treaties, and if the parties can't agree to a standalone arbitration body, to have the dispute resolved before the brand new Permanent Court of International Justice that had been established in Geneva. That court later would disappear with the fall of the League of Nations, and it was reconstituted as the International Court of Justice, which now sits in The Hague, and that has the authority to hear cases when states consent to have those cases heard there. Now, as I mentioned, that Turkey had not ratified the Treaty of Sèvres, and no other nation that was a party to the treaty had ratified the Treaty of Sèvres. Events took hold. Power, in particular, played an important role, and we actually saw the decline of the Armenian Republic very quickly. By December of 1920, there was not an Armenian Republic really to sign the treaty or to ratify the treaty. And then we saw in 1921 the Treaty of Kars, in which the Grand National Assembly of Turkey, the government of the Socialist Soviet Republic of Armenia, and other of those republics entered into an agreement establishing borders with the Soviet Union. And of course, questions about whether the parties that signed this treaty even existed, had the legal authority to enter into this treaty. But more importantly, in 1923, at least for the issue that I'm focusing on, the question of the Treaty dealing with the borders between Armenia and Turkey, and the Allied powers entering into another treaty with Turkey, this time Turkey in a much stronger position and establishing the borders as they largely exist today. No specific mention at all of Armenia, and that treaty was promptly ratified. So, you're probably wondering, there's a missing piece here. And that missing piece is the Woodrow Wilson Award. Woodrow Wilson, who by the time the treaty had been signed, I believe he had already had his stroke, but he was very concerned about the Armenian people and understanding that the Treaty of Sèvres would not resolve the Armenian-Turkey frontier, that the United States was not prepared to recognize the Armenian Republic, it was prepared to recognize the Armenian Republic, but was not prepared to support a mandate that it would protect. It wasn't even prepared to sign off on the Treaty of Sèvres, but the President of the United States remarkably agreeing to arbitrate the issue of the frontier, as I described earlier, and also, of course, to deal with access to the sea and demilitarization protection. And so within 3 months after the treaty was signed, the treaty signed in August 1920, in November of 1920, we have what is called the Wilson decision. And it's a very, it's relatively short decision, but he goes through and he documents how the frontier would be established. And a lot of the frontier lands are now in what we call in Turkey. And it provided for access to the sea, and it also talked about security and demilitarization. The interesting thing about this award is that it appears it was sent to the League of Nations, to the Council of the League of Nations. Usually in arbitration, international arbitration, at the end of the arbitration award, it will talk about that this has been sent to the parties this day, identify who receives it. He did have a covering letter, though, and he indicated that this was being sent to the council. Question whether the council ever sent the award to the state parties who had signed the treaty. This is just some digging that needs to be done, but I think it's important because it does establish who knew what when. The interesting aspect of this is that many times when you have an international arbitration, there will be set out in the document establishing the right to arbitration, the standard, the applicable legal standard. President Wilson talked about he used general justice principles in reaching the result that he did. It's not clear if there was ever an oral hearing. I don't think there was. President Wilson had in front of him, based on documents that we have pulled up, he did have a fact-finding report submitted by an American commission, military officers who had been in the region. There had been questionnaires they sent to missionaries and the answers they had to those questionnaires. There was a report of the War Department of the United States, but also there were maps, and he specifically relied on a Turkish general's map, a staff map, in working through the boundary issues. So now we have this award, and there has been an argument that this arbitration award is a valid legal document, as enforceable under international law. And what I have worked through in my paper is that that's a long stretch. It's a long stretch by for a number of reasons. But there are some issues that perhaps we want to focus on that require some additional work, and it's those things I'd like to spend a little bit more time looking at here in the last few minutes of my remarks. I would like to focus on international law, though. The Treaty of Sèvres was not ratified as set out in the treaty. When the treaty prescribes a method for ratification, then the states must follow that. The whole notion of obligation under international law for a treaty is based on state consent. States define how they consent. It was very specific. There's no question there was no explicit ratification consistent with the treaty, and therefore the treaty does not create binding legal obligations. This is a basic principle of international law. It was recognized at the time the Treaty of Sèvres was signed. It is now what we say even further respected in the Vienna Convention on the Law of Treaties, which is a multilateral treaty that lawyers use, states use to give effect to treaties. What are the rules in interpreting treaties? That Vienna Convention came in effect in 1980, but there were cases in the 1920 time period by the Permanent Court of International Justice looking at treaty standards and applying general principles. And one of the well-established principles is that you have to have ratification consistent with the way the treaty has set this out. And in fact, there are two decisions of the Permanent Court of International Justice that have specifically acknowledged that the Treaty of Sèvres has no binding effect. They were looking at it in the context of a dispute between Greece and the United Kingdom, as well as then an advisory opinion that was issued by the PCIJ concerning the Treaty of Lausanne, the second treaty that came into effect in 1923 after the Treaty of Sèvres concerning the frontier. And the Permanent Court of International Justice, recognizing that the Treaty of Lausanne is the governing treaty, and the Treaty of Sèvres had no effect. Interestingly, there has, in the last 10 to 15 years, been an arbitration between Eritrea and Yemen dealing with certain islands. And one of the questions was, did Turkey have authority over the islands? Did it pass authority? And that dealt with the validity, again, of the Treaty of Sèvres, and the tribunal there saying the treaty has no binding effect. Now, the question then is, if we had the Treaty of Sèvres that was signed, but it is not legally binding on Turkey, does it have any legal significance at all? State parties went through this enormous exercise to have a treaty signed. What consequence, if any, does it have? Or are we solely going to look to the Treaty of Lausanne as establishing the frontier issues? There is a principle, again recognized well under international law, that upon signing a treaty, a state party is obliged to refrain from acts which would defeat the object and purpose of the treaty until a state party, quote, makes its intention clear not to become a state party to the treaty. Now, we know that by the time the Treaty of Lausanne was signed in 1923, Turkey made it very clear that it was not going to be bound by the Treaty of Sèvres. But was there a time earlier? Was there a time 2 to 3, 4 weeks after the Treaty of Sèvres was signed where Turkey made it clear it was not going to ratify the treaty? That the information that we need to glean to establish could shed us light on potential obligations that Turkey had during this time period under international law. That's why the report that I had mentioned earlier about the professor from Ankara who had done this work signaled that it was very early after the treaty was signed that the British knew Turkey was never going to ratify due to the political situation. But even if we were to establish that from 1920 to right on the eve of the Treaty of Lausanne, it was clear that Turkey had not indicated it was not going to be a party to the Treaty of Sèvres and ratify it, I think any remedy that you would have would be quite limited. And it wouldn't be an attempt to try to redraw the boundaries. There could be some attempt to establish a violation of this principle, and I think it would be an interesting exercise to figure what the remedy would be. Another argument that is out there again, this is based on facts, is even if the Treaty of Sèvres is not binding, was there an independent legal basis for President Wilson to arbitrate? And, for example, are there letters between Armenia and Turkey exchanging positions on recognizing that President Wilson would go forward with this? Did Turkey participate in the arbitration? Sort of an acceptance then, a recognition that it understood the importance of this. Did Armenia participate? These are factual issues that need to be worked out. Again, another long stretch argument, but it's something to think about. That's the focus. The argument should be, rather than saying we have this Wilson Award and we have the right to take it to an international court and have it enforced. There are two other principles that I would like to focus on and then conclude. And that is the basic principle, again recognized by the Vienna Convention on treaties, and that is that state parties are free to sign a new treaty, even if they are a party to a previous treaty. Now, the problem we have is that not all state parties to the Treaty of Sèvres signed the Treaty of Kars or the Treaty of Lausanne. But a recognition that a later in time treaty is going to be the one that would govern if there is a previous conflicting treaty. This gets into the authority issue of what nations existed at the time, what authority did they have to sign any subsequent treaties. But there is no question, at least before the PCIJ, that the Treaty of Lausanne, the 1923, is a valid treaty. It had to rule shortly after the treaty went into effect on the validity of a process in that treaty that authorized the Council of the League of Nations to resolve the dispute between Turkey and Iraq concerning its boundaries. And it appears that Turkey may have been putting up some resistance to having the Council resolve it, as set out in the treaty. And the case went to the International Court of Justice for an advisory opinion. The Council is saying, tell us how we should proceed. No question at all that the court said that you have an obligation under the Treaty of Lausanne, and this is how we think the Council should go forward in resolving the boundary issues between Turkey and Iraq. Finally, there is at least principles in international law that could be relevant to understanding state conduct and how we should put state conduct in a certain light. And that is the recognition of equitable principles. There is within the statute establishing both the Permanent Court of International Justice and the International Court of Justice a provision that identifies sources of law. And general equitable principles based on fairness and just are not principles that just courts will apply unless the parties have agreed. Yet the statute also talks about that one of the sources is general principles of international law recognized by civilized nations. The court has acknowledged that some of these general principles can be equitable principles. Equitable in the sense that they can aid the interpretation of a treaty, aid the court in adjudicating rights between states. Now, it would be a very hard-pressed argument to make that even if Armenia itself had the claim, because only states can appear before the court, that they can invoke an equitable principle to establish a frontier or to establish a claim based on genocide. Those equitable principles, however, can actually be used by Turkey against Armenia if there was ever any challenge to the current frontiers. And equitable principles such as acquiescence and estoppel, not an affirmative basis of a claim, but perhaps principles the court could use, and I think would be important to Turkey to be able to use to establish any attempt to try to deal with boundary issues, such as for many years Armenia and Turkey have been side by side. The International Court of Justice has recognized in some cases that a state party who has a gripe about a boundary, if you have a gripe about a boundary, you need to assert that claim. And you can't take advantage of the peace you've had with the boundary and then later on and try to say that we want a different boundary. And have you given specific acknowledgement to the boundary? This is a very factual issue. Again, finding out in what instances Armenia has made any acknowledgments, and it goes beyond boundary issues too. But it's been 90 years, and the way I would analogize it, it's a bit difficult to unscramble the egg. And those are the kind of arguments I think that will, based on equitable principles, that and state conduct that could be relevant to any claim, and I think could be quite serious in terms of how any court or tribunal attempting to assess a claim would look at the merits of it. And so, in conclusion, let me just note that there needs to be considerable care and respect for international law in assessing treaties, and particularly the Treaty of Sèvres, and also in assessing the Wilson decision. The treaty really was a promise of hope for the Armenian people, but it was at a time when power and politics were vulnerable. And it was a promise that was not realized. It did launch a chain of events, and I think it's important we understand that chain of events in this legal context. And full consideration of the international legal ramifications requires a complete development of the factual record as to the Armenian-Turkey frontier issue. And the passage of time has diminished the likelihood, I think, that the frontier, as established by President Woodrow Wilson in his 1920 decision, could become a legal reality. Let me stress that my remarks here do not attempt to deal with individual claims or church claims and others that Armenians may have based on their prior ownership of property in Turkey. That is a separate issue, one that arguably is based on what we call local or municipal law. There could be international standards that come into play with that. And then finally, my analysis has not attempted to address the issue of the massacres on Turkish soil that have not dealt with, the perpetrators have not been held accountable before an international tribunal as contemplated by the treaty, although those individuals are probably long gone. The critical question, I think, in that regard is state accountability for these acts. But that's a different issue and one that I did not address in this paper because I really wanted to focus on the Wilson Award and the frontier issues. So thank you very much.
Thank you so much, Susan, for a realistic, enlightening presentation. And since you will be leaving very soon, I think we should take advantage of your presence here to see if there are some comments or a few questions. I think Professor Zayas wished to say something, so we'll make an exception to the way this conference is organized. Usually we will have the discussion at the end of the sessions, but this is a particular case. So Professor Zayas, please come. No.
Should I come up there?
If you wish, sorry.
Okay. Thank you, Professor Astourian, and thank you, Professor Karamanian. On the issue of boundaries, obviously Article 62 of the Vienna Convention on the law of treaties, the famous clausula rebus extantibus would not allow for easy modification of frontiers because of change of circumstances. On the other hand, I dare think that there is a possibility to challenge the validity of the Treaty of Lausanne. Why? Article 53 of the Vienna Convention of the Law of Treaties, if the treaty were to be negotiated now, it would be ab initio, ex tunc, it would be invalid because it would go against a number of peremptory rules of international law, what's termed jus cogens. What do I want to say? Condoning the consequences of genocide, not removing the consequences of the Armenian genocide and the crimes against humanity by Turkey, as that's a net result of the Treaty of Lausanne, which essentially acquiesces with the murder and with the theft of the Armenian property, that vitiates the Treaty of Lausanne. But of course, the Vienna Convention of the Law of Treaties has no retroactive application, and it says so specifically. On the other hand, there's another article of the Vienna Convention of the Law of Treaties, Article 64. And Article 64 says that if subsequent to the entry into force of a treaty that was valid and legal in 1923, if subsequent to the entry into force of that treaty, a new peremptory rule of international law emerges that trumps the treaty, that shows that the treaty is no longer compatible with modern international law. And which are those principles? Certainly, the self-determination of the people of Armenia. I mean, you cannot deny self-determination by exterminating a nation. You cannot deny the right to life of the Armenian people by deporting and killing them. So it's quite clear that anything having to do with genocide and crimes against humanity would vitiate the validity of the treaty. As I said, Article 64 of the Vienna Convention of the Law of Treaties. I haven't seen anyone argue that yet. I mean, everybody seems to argue Treaty of Sèvres was never ratified. On the other hand, the Treaty of Sèvres does have an utility, and that is not in the context of boundaries, but far more in the context of the claims for the genocide, for the murders, for the return of properties that belong to the patriarch, that belongs to the people, the cultural heritage of the Armenian people. And there, I think that the Treaty of Sèvres constitutes really extremely solid and convincing evidence of the consensus, of the conviction of the international community in 1920 that crimes against humanity had been committed, that pursuant to Article 230 of the Treaty of Sèvres, there was an international obligation on the part of Turkey to hand over the criminals and to have them punished, and Article 144, which is the article on restitution of the properties. So, having said that, as a comment, I had a second comment, but I see your presence here probably means enough. Okay, very good, very good. No, but I mean, I just thought that it's a thought that obviously deserves consideration. You know, to what extent can we...
Let's allow Dr. Karamanian to address these issues, please.
Yeah, thanks.
Yeah, thank you very much for those comments. I'm really going to probably just address the first one, because I think that the second one is it's a bit of a stretch. But even for the first one, as I mentioned, the International Court of Justice, the PCIJ, has recognized the Treaty of Lausanne. For years, nobody has challenged this treaty. And I think that on some type of equitable grounds, it's going to be very, very hard to make an argument that, since 1923 to the present, we've known about these atrocities. They've been well publicized, and we have done nothing to try to undermine this treaty. And that is there have been so many years of complacency, and perhaps that was part of the grand design, to allow some sense of satisfaction in having a state within the Soviet Union. Unfortunately, the inability of the diaspora community to organize to address the kind of issues that you have just raised. But it shows how potentially fluid this is. But before serious arguments are made, the other question is the forum. Where could such a claim be raised, and who can raise it, in what forum, and particularly given who is a party to the Treaty of Lausanne, to the nation states.
We are going to take about 2 to 3 questions, because I don't want Dr. Karamanian to miss a flight. Dr. Serge.
Yes. Yeah, I have a question to Dr. Karamanian, because... Sorry. Can you hear me? Yeah. I have a question. I tried to find that in the literature related to international law, but that I could not find it. I wonder what your view is on whether the Turkey that has ratified Lausanne is the same Turkey that signed Sèvres, or is the Republic of Turkey the result of a dissolution of a country like the Austrian-Hungarian Empire, of which new states have been created, like Syria, like Lebanon, which were put under French mandate, Jordan, Palestine under British mandate, protectorate for Iraq, and the Republic of Turkey. Is it the same Turkey? This is a very important question under international law.
No, I think that's an excellent question. And it's a question that you have to ask for a number of the parties to, well, obviously with CARS, as well as with Lausanne. And I'm not prepared to give you an answer on that, because I think it is within the internal files of what exists in Turkey. But what we saw was the signers of the Treaty of Sèvres being, in effect, disowned by their country very quickly, and a change of authority. And there has to be some principles of state succession that would say that, I would think arguably, that it is the same Turkey that exists before, at least was acknowledged as such. So, do you, Professor, have? Obviously, yes. Yeah. I mean, there could be something in the Turkish files that would say, oh, we have a new government here, but I don't think we're going to find that.
I would like to ask you about the Treaty of Sèvres and its significance today. Why would you think, do you think that the Treaty of Sèvres serves any way in the development of Armenian-Turkish relations? Do you think that it has a positive or a negative influence in the legal dimensions of contemporary Armenian-Turkish relations?
Well, I think that the treaty does show the intention of a defeated Turkey at the time, its attempt to perhaps buy time, its attempt to buy complacency. It perhaps knew the vulnerabilities of the Allied powers. It knew what was going on internally, but there is also, when you think about it, recognition of the validity of arbitration and these means of dispute resolution. I think that that's very important. And even in the Treaty of Lausanne, as you saw, the similar way of, if we can't resolve our border issues, we will have a a council resolve those issues. I think that is important in terms of an expression by Turkey consistently to have peaceful means to try to resolve these kind of issues. I'm always trying to think about going forward. I think this conference here today is designed to go forward. What areas has Turkey expressed its well-established practice of Turkey that perhaps would be ways to politically get them to come to the table? And having neutrals was one of them. They have done that before. To me, what I find absolutely fascinating is if any action at all was taken internally with regard to the Wilson decision. What did Turkey do? If it didn't know about the decision, what did it do after this decision? Was there any attempt to challenge it? I mean, by this silence, one could say that perhaps if there had been some other independent reasons for Turkey and Armenia to agree to have Wilson resolve this, that would be a very important fact. I think that also the acknowledgement of massacres, clearly important, and that Turkey did act on some of those obligations. I think that's very, very important, and you see minority rights mentioned also in the Treaty of Lausanne. So.
Final question. Yes, sir.
What's the basis for saying that the Wilsonian arbitration award has some sort of a binding force when the treaty that it derives its authority from doesn't have any legal binding force?
Yeah, that's something that I think all of us who've been looking at this are a bit perplexed. The best spin I can give on that argument that is being made that I don't agree with is that the person who's arguing it says that there was a compromis, there was a consent by the two nations to have this arbitrated. And the consent was one on the signing of the treaty, but the problem is the treaty says it has to be ratified to be valid, okay? Or two, that perhaps there's some other independent agreement between Turkey and Armenia to have this decision to be binding. That's the only way I can realistically assess the argument. The same argument, I mean, when this argument is being made, they're also saying that the Wilson decision has been ratified. I saw that in print. And I'm like, what? I mean, you ratify a treaty, you take an arbitral award, and you seek to have it enforced, and that hasn't been done as well. So, thank you very much.
You're welcome.
I can stay for 12.
Excellent. I think I know who will take you to the taxi, you know?
Okay, thank you so much.
Because
I'm
my
sorry,
son has to leave also
9
at that
a.m.
time.
tomorrow morning. My flight will get me home at 1 a.m. So.
It is my distinct pleasure also to welcome Professor Serge from the University of Paris-VIII, Pantheon-Assas, which is the most prominent legal university in France. Professor Sur is agrégé des facultés de droit. That doesn't tell you much in English, but basically agrégation is a national competitive exam, and it is particularly difficult in the legal field. He was associate director of UNIDIR, the United Nations Institute for Research on Disarmament at Geneva. He is director of the Thucydide Center for Analysis and Research in International Relations at the Université Pantheon-Assas. He established, founded, and directs the yearly l'annuaire français de relations internationales since 2000, which got a very nice prize from the Fondation Bonnefous of the Academy of Moral and political sciences, and he is editor-in-chief of a journal called Question International, which appears six times a year. He has taught and held position at the Academy of International Law at The Hague, where he was Director of Studies in French languages and responsible for a course on public international law. His publications are a little bit frightening for people like me, depressing, I would say, but I will only mention one because that tells you about the importance of it. His book on which is the main treatise on public international law, published by the main company that deals with legal publications in France, is going through its 9th edition today, and received the prize of the Academy of Moral and Political Sciences. And I would like to invite Professor Serge to talk about Sèvres Treaty 1920, Kars Treaty 1921, Lausanne Treaty 1923, what relevance to the current Armenian situation. Thank you for coming.
Thanks a lot, dear Stephan. I am very glad to be here. I am very grateful to the organizers of this event to have invited me in this sunny Sunday in Berkeley. But at the same time, I am a little bit surprised to be here because my English is poor. I know quite nothing about Turkey, about Armenia, and even less about Armenian-Turkish relations. So what I could do is to have a kind of distant legal comments about the legal situation regarding the treaties at the end of the First World War. And basically, I think I have to deal with the problem of frontiers, boundaries, leaving the question of massacres and genocide for this afternoon, and to deal with the question of boundaries between Armenia and Turkey. For that purpose, we have 3 treaties at stake, which have to be examined: Sèvres, Kars, Lausanne. They concern the post-First World War situation regarding the border of Turkey with its neighbors, some of them being new states. I don't think Turkey was a new state. I think there is a principle of continuity of state which supersedes the internal changes. For instance, if you look at France before the revolution, France after the revolution is always the same state, even if you have a huge internal change. Sèvres was a treaty in the line of the Versailles Treaty, imposed to a defeated state, very strong against Turkey, and on the opposite, very favorable, very positive for Armenia, which was recognized as an independent state. Nevertheless, as we have seen, its boundaries were not fixed, and the decision was supposed to be taken by the President of the United States. But in fact, as we have heard, the treaty was never ratified, so was never in force. So I think it's not really useful at this time for us to examine the border question. In fact, it's a kind of draft treaty, but not a treaty, no legal authority at all. I would say that Lausanne Treaty is not relevant either. Armenia is not a party to this treaty, and the country's borders are not at stake. Lausanne Treaty could be interesting for Armenia as far as minority treatment is concerned, but not as far as boundaries are at stake. So, at the heart of the matter, we find the Treaty of Kars. Is this treaty in force? Could it be voided, nullified? What about the boundaries it has established between Armenia and Turkey? To examine these questions, we must firstly identify the legal basis. What are the rules pertaining to its evaluation? Then we have to reply to the various questions raised by the current relationship between Kars and the Armenian-Turkish border. So I will devote my first set of remarks to the international rules for an evaluation of the Kars Treaty. And from the intervention of Professor Karamanian, it's very clear that we have three sets of rules. First set is the international law of treaties. International law of treaties is basically a customary law. And that customary law is embodied, is codified by the Vienna Convention of '69, Vienna Convention on the law of treaties. As customary law, even codified, it's a law which is compulsory, binding for all states, whether they are parties or not to the Vienna Convention. There is an exception, which is the problem Professor Zayas was referring to, jus cogens, which is mentioned in Article 53 and 64 of this convention. Jus cogens is part not of a codification, but of a development of law. So I don't think jus cogens, maybe we could have a discussion with that, with Professor Zayas after about that, but I don't think jus cogens has any relation, any pertinence with the Kars Treaty. So that's the first set of rules, the main set of rules, international law of treaties. Second set of rules, it's the problem of state succession. State succession because Armenia is by now the successor of the Soviet Republic of Armenia, and in this respect, a successor of Soviet Union. And when the treaty was concluded, the legal situation of Armenia was a little bit shaky. Armenia was an initial part of the Kars Treaty, but his relationship with Russia was a little bit unclear. We can find some rules regarding state succession in the Vienna Convention of '69, but there is also a specific treaty on state succession regarding treaties, which is a convention of '78, but that convention enjoys a limited number of ratifications and could not be considered as expressing the customary law. So, in some respect, we will have to consider customary law. And the third set of rules are the rules regarding the statute of boundaries in international law. All the rules concerning the borders are not necessarily part of treaty rules. Maybe there are specific legal considerations pertaining to the boundaries. And we will have to see what the customary law says about the status of boundaries. So, for our examination of the Kars Treaty, we will consider the general international law and eventually enlightened by the decision, by the judgments of the International Court of Justice. I can now deal with my second set of observations, legal questions regarding the appreciation of the Kars Treaty. I think we can deal with 4 main questions, and some of them necessitating subdivisions. First question was, in 1921, Armenia a state able to conclude international treaties? Some could argue that in fact Armenia was not a sovereign state, but was under the umbrella of the Soviet Federation of Russia. But what we see in the Kars Treaty, I have the text with me, maybe it would be possible to make copies. It's in French, but it was the original treaty. Probably there exist English versions, but I have not found it. I have always worked with the French version of this treaty. Armenia was a party to the Kars Treaty, and Russia was also in the negotiation, but with a specific position. The main negotiators were Armenia, Azerbaijan, Georgia, and Russia had a specific position, participation to the negotiation, even if after that Russia was signing the treaty. So I think with that we have the solution to the question: was Armenia a state able to conclude international treaties? Turkey was recognizing the international capacity of Armenia at this time. It has already recognized that capacity with the Sèvres Treaty, but Sèvres Treaty was not in force. So it was a new recognition in a way, and was recognizing the sovereignty of Armenia. So did Russia at this time. So even if we consider that Armenia was already a part of a Soviet federation, it would not have impeded it to conclude international treaties. And we have an example, a modern example, with Ukraine and Belarus, which were part of the Soviet Union and at the same time members of United Nations, so parties to the Charter of the UN. So the fact to be a component, to be a republic from the Soviet Union, did not impede states to conclude by their own international treaties. So I think there is no question, in fact, about the international capacity of Armenia to conclude the Treaty of Kars. The second question, in a way, is the main one. Is it possible to legally claim the invalidity of the Kars Treaty? And it could be done in 2 ways. It would be possible to claim that the consent of Armenia at this time was not a free consent, that there was some vice in it. It would be an invalidity of the consent. And another way would be to claim an invalidity of the treaty itself. So let's refer to the Vienna Convention, which provides a lot of considerations and rules, regulations about that, with a distinction between invalidity of consent and invalidity of treaty. As far as the invalidity of consent is concerned, we could find in the Vienna Convention 5 motives. 5 motives which could be invoked. These motives are formulated in the Article 46 to 50 of the Vienna Convention. Article 46 deals with provisions of internal law regarding competence to conclude treaties. It means that if a state violates its own rules, its own domestic rules regarding the conclusion of treaties, this state could after that claim that its consent was not valid. But it must be first only procedural rules, and second, main procedural rules. Meaning, for instance, if a ratification supposes an authorization from a parliament, from a legislative body, and that authorization was not obtained or was not asked for, you could claim after that the ratification is void because it was not made according to the domestic rules. But it has to be main procedural rule, meaning if you had to consult to get a consultative advice from a consultative body and you have forgotten to get it, no matter, it doesn't nullify the ratification. So in this case, I am not informed. I don't think it could be possible to state that the domestic procedure of Armenia at this time were not respected. I have, at least I have no information about that. I have not seen any claim about that as well. Second motive is Article 47, which in a way is close to the first motive. It's in the case of specific restrictions or authority of the representatives of the negotiating state to express the consent of the state. The hypothesis is a representative has signed a treaty, but he was not authorized to sign it. So after that, the state could claim, I have not, my consent doesn't exist because the representative had no authority to sign. In fact, for the Kars Treaty, the representatives were Mr. Askanas Mravian, People's Commissary to Foreign Affairs, and Mr. Pogos Makinzian, People's Commissaire to domestic affairs, internal matters. So there is no reason to suspect that the People's Commissaire to the Foreign Affairs had no competence, no power to sign a treaty. So, and Article 47 adds that to be invoked, such a vice, such a restriction of consent must have been notified prior to the consent to the negotiating states, to the other parties. We see no trace, no element indicating that Turkey was informed of any restriction from the Armenian negotiators. Article 48 is maybe more substantial. It is the idea of an error, a mistake in the treaty. Consent has been founded, has been given on the basis of an error. And it happens, you could have error in the treaty. If it is the case, the consent of the mistaking state could be invalidated. But first, it has to be an error on the facts or on a situation, not on the law. You can argue, I was mistaken in my interpretation or knowledge of the law, because you are supposed, as a sovereign state, to have knowledge and to be well informed and to interpret the law in good faith. So you cannot argue that you were ignoring the law. But if there is a mistake relating to a fact or to a situation, and if this mistake was the very basis of your consent, then you could argue that your consent was in a way not given. Can we find in the Kars Treaty elements of that? If it is the case, okay, but for my part, I have no evidence of that. The two next articles could be joined because Article 49 deals with fraud and Article 50 with corruption of a representative of a state. So there is evidently a link between the two. fraud is a fraudulent conduct of a state conducing a partner to conclude, to inducing a party to conclude. And corruption is a way to persuade a negotiator, a representative, to accept a treaty. Well, we are not aware that the honorables Askanas Mravian or Pogos Mackenzian were corrupted. Or at least there is no evidence of that. And you must have evidence. And not only you must have evidence, but you must also prove that the corruption is the fact of another negotiating party, which is probably very difficult. Anyway, the corruption may be welcome from Russia, which is also a party to the Kars Treaty. And in addition to all these motives, to these 5 motives that we have just mentioned, they could be invoked only by a state party when it can prove it, it has to prove it, and he must claim the invalidity of its consent in a short delay. After having knowledge of the motive, if he continues to accept and to implement the treaty, he is supposed to have made an acquiescence to the treaty. So I don't think on this basis there is any motive to contest the validity of consent of Armenia, neither the capacity of Armenia to conclude the treaty, nor the validity of its consent. What about another motive of invalidity, but not of the consent, of the treaty? Two are relevant. I make here a simplification which will not escape to Professor Karamanian. She will forgive me, but I have to simplify a little bit in this respect, otherwise it would be very, very complex. We have two motives which all are related to violence, but they are very different in their target and in their effects. I refer to Article 51 and Article 52 of the Vienna Convention of 1969. Article 51 regards violence or coercion against the representative of a state, representative or his family. Was it the case? That cannot be excluded, that there was some coercion against the negotiators. That cannot be excluded. But it has to be proven at the same time. And if it was the case, the consent would be without any legal effect. It would not be a relative nullité, comment dit-on, nullité, annulment. It would be an objective and absolute one. But anyway, we have the same problem of proof. Article 52 is a different kind of annulment, of voiding the treaty. It concerns the coercion of a state by the threat or use of force in violation of the principles of international law embodied in the Charter of the UN. I quote the text of the Article 52. But I think by definition, this article is not relevant for the Kars Treaty, because this treaty was concluded well before the existence of the UN Charter and of the principles which are embodied in the UN Charter. Otherwise, all the peace treaties which were concluded and which have established borders before the entry into force of the Charter would be void. Versailles Treaty would be void as well. and Trianon Treaty, and so on. This article is generally considered as part of jus cogens, and I was not in the idea of discussing here the concept of jus cogens, but maybe we will have to come back to that with Professor de Zayas. Anyway, a rule of jus cogens is not retroactive. So even if we consider that this rule is a rule of jus cogens, it cannot be applied to the Cars Treaty, and even to the Lausanne Treaty. That's for the second question, which is the main in a way. Could be some claim for the invalidity of the Cars Treaty. I think the response is negative in absence of any factual or legal evidence of the contrary. The third question is, what are the legal effects of state succession for the Cars Treaty? The independence of Armenia has created a state succession with Soviet Union. Could that generate legal effects for the Cars Treaty? I think we could have a look first at the Vienna Convention of '69, and one could claim that such an event, such an independence, is a fundamental change of circumstances that could justify not the invalidation of the treaty, but its termination, the end of the treaty. It's clausula rebus sic stantibus, which was mentioned by Professor de Zayas. It is generally considered that treaties having been concluded in a certain context could depend on that context. And if the context was the main reason for the conclusion of treaty, the disparition of this context could lead to the termination of the treaty. But whatever these circumstances, in the case of Armenia, there is a para 2 in the Article 62 of the Vienna Convention, and this para 2 of Article 62 expressly states that rebus sic stantibus doesn't allow the modification of boundaries. So it means that you cannot invoke any modification of circumstance to put in jeopardy the established boundaries. The same conclusion arises from the other rules. Maybe the Vienna Convention of 78 rules on succession to treaties. The principle about succession of states in the field of treaties is that a new state is free of any obligation accepted by its predecessor. It's the principle of tabula rasa, meaning the state is sovereign, so is devoid of any obligation which was accepted by the predecessor. For instance, Algeria, becoming independent in '62, is not a party to NATO, to the Treaty of Washington, is not a member of the European Community at this time, is not a member of United Nations. Algeria has to be admitted at the United Nations. So, tabula rasa. But there is also an exception concerning boundaries, because a new state is supposed to accede to sovereignty in the territorial content and limits of its predecessor. For instance, for Algeria, Sahara was part of Algeria, even if it could have been arguable. But the predecessor has considered that Sahara was part of Algeria as a colonized territory. So, accessing to independence, Sahara was part of Algeria. It is by now a customary principle of law, of international law, known as iuti possidetis iuris. It's a principle of succession, an exception to the tabula rasa principle. You must accede to the territory which was under the jurisdiction of the predecessor state. This is a principle which is confirmed, which is consubstantial, I would say, to the practice, to the international legal practice. In Latin America, in the 19th century, in Africa, in the 20th century, then in Europe, after the dissolution of Soviet Union and even Yugoslavia and Central Asia, we have seen that the new states, the new republics, were accessing to independence in the boundaries, with the boundaries of the predecessor. We could always find some exceptions. For instance, with the Comores, and maybe in a way we could also discuss Kosovo. But these exceptions confirm more the principle that they excluded. It doesn't mean that you could not have agreements between states to modify boundaries, but state succession as such doesn't modify established boundaries. I will now pass to my last question, and in a way it's a conclusion. It's a way of invalidating all that precedes. Are the Armenian boundaries with Turkey dependent of the Kars Treaty? If they are not dependent, what we have said till now is not really useful. But it was useful to eliminate some questions. In fact, we must admit, at least it's my position, that whatever the fate of the Kars Treaty, enforced or not enforced, valid or not invalid, it is without effect on the boundaries, because the situation of the borders become independent of the legal instruments which are at their origin. A lot of treaties are no longer in force, but the territorial situation which was established on their basis remain. It is in a way an objective situation which is seen as well and recognized and accepted by the states. It is binding for everybody. And as far as I know, the current government of Armenia has never contested the current boundaries. So there is a confirmation, even if in the protocols of 2009, you have a confirmation of the boundaries. And to illustrate that assertion, we could take a judgment of the International Court of Justice in a case which has some comparison is interesting between the Armenian situation and this one. A case concerning the territorial dispute between Libyan Arab Jamahiriya, at this time it was the Gaddafi's rule, and Chad, about a portion of territory between Libya and Chad named Ausu Strip. Ausu Strip was a part of territory that Libya was claiming against Chad. At the beginning, there was an agreement between Italy and France, which were colonizators of Libya and Chad, respectively. And that agreement was establishing a border between their possessions. It was at the end of the 19th century. In 1935, there was another treaty between France and Italy, leaving to Italy that Ausu Strip, which is in the south of Libya and which is supposed to be plentiful of natural resources. But that treaty of 1935 was never ratified. never ratified, never in force. And then, 20 years later, in 55, another treaty was concluded between France, always sovereign in Chad, and Libya, at this time independent. And there was a reaffirmation of the borders. But Libya was claiming part of Chad territory. And the two parties, the two countries, accept to submit the dispute to the International Court of Justice. And it was settled by a judgment of 3 February 1994, and it's very clear. I quote two para of this decision, which is a very long one, and which gives every satisfaction to Chad. The establishment of a boundary is a fact which, from the outset, has had a legal life of its own, independently of the fate of the 1955 treaty. Once agreed, the boundary stance for any other approach would vitiate the fundamental principle of the stability of boundaries, the importance of which has been repeatedly emphasized by the court. And in the para 73, the court follows a boundary established by treaty, thus achieves a permanence which the treaty itself does not necessarily enjoy. The treaty can cease to be in force without in any way affecting the continuance of the boundary. So from this jurisprudence, which is very clear and very strong, it comes that whatever the fate of the Kars Treaty, whether we accept it or not, the boundary stands because it's a fact, a situation, which was accepted by the two states. So one could ask, maybe I am too long, no? No. I am concluding by now. One could ask why in the 2009 protocols between Armenia and Turkey, which are not ratified, why indicate that the parties reconfirm, that's the wording, their commitment to territorial integrity and to the inviolability of borders. I think there is no important conclusion to be drawn about that, because it's only a reassessment, reconfirming. It's not an establishment, a kind of recognizance. It's only a recall, which is usual in that kind of documents. For instance, in the Helsinki final declaration of 1975, we find a reference to the principle of the Charter, to the territorial integrity as well. It doesn't mean that there is nothing new in these statements. And what is important maybe to state is that it doesn't impede any further modification of the treaty. It doesn't mean that the borders are intangible. They are inviolable, but they are not intangible, as far as it is done by peaceful means and agreed upon by concerned state. For instance, the Helsinki Final Declaration of 1975 never impeded the German reunification, so a modification of boundaries in Europe, as well as the dissolution of Yugoslavia. That's fairly different. Inviolability and intangibility are two very different principles. With that, Mr. Chairman, I conclude my examination. Maybe the conclusions are not so positive, but I am only on the legal point of view. Thanks a lot.
Well, I think we are spoiled this morning. I would like to thank you for your meticulous analysis of the Treaty of Kars. We are going to start again with the participants to see if they have some comments, and then you'll have a chance of asking 3 or 4 questions, and then we'll take care of our stomach and have lunch. Professor de Zayas.
Thank you, Professor Astourian. I dare return to my argument of peremptory rules of international law, to the emergence of new rules of jus cogens. Everybody agrees that the prohibition of genocide and the prohibition of the use of force in that context constitutes a jus cogens principle. Now, to the extent that the treaties of Lausanne and Kars are incompatible with this prohibition of genocide and the prohibition of recognizing the situation that emanated from that genocide, this erga omnes obligation not to recognize the consequences of genocide. To that extent, both the treaties of Lausanne and the treaties of Kars can be questioned. Now, everybody agrees also that colonial treaties have fallen by the wayside because they are no longer compatible with modern international law. I'm not saying extunc, I'm not saying ab initio. I am saying that a new rule of international law has emerged, and pursuant to Article 64 of the Vienna Convention of the Law of Treaties, any treaty that is incompatible with it falls. Now, as to the earlier argument on the validity of Kars and the application of Articles 45 to 52 of the Vienna Convention of the Law of Treaties, there I have my questions. It's, of course, it's a factual issue that has to be determined. To what extent the then Armenia and the then Turkey had the capacity to conclude this treaty. I'm not saying 1923 or 1930. I'm saying 1921. Was Turkey, this construct of Kemal Atatürk, already coagulated into a state that had that capacity? Or for that matter, the Soviet Republic of Armenia. Did they have the capacity there? Was the consent at that moment valid? That is a factual question, has to be clarified, but everybody agrees that law is not mathematics, and we cannot apply the Vienna Convention of Law of Treaties as if it was mathematics. You don't get the result as a computer is going to give it to you. And I think that what's very important is what you said at the end, and I thoroughly agree with that, Helsinki, final act. The fact that these are arguments that you can throw in to show that there is an imminent injustice that has not been corrected. Now, Turkey is not going to voluntarily give back any territories or to give back any monies. But if the message is out and if there's a perception in the international community that this injustice is no longer tolerable and that there has to be reparation for the genocide and reparation for the destruction of the cultural heritage of the Armenians, then there is the possibility peacefully in a negotiation pursuant to the Helsinki Final Act to reach some sort of accommodation between the parties concerned. Now, you mentioned also uti possidetis, my last point. Uti possidetis, I think, is thoroughly obsolete. Uti possidetis made sense in the 19th century, and it made sense temporarily. And I think it caused countless trouble when uti possidetis was applied in the context of decolonization in Africa. I really think that the injustices of uti possidetis in Africa are paramount to have really accepted totally arbitrary frontiers that the colonial powers imposed on the continent of Africa. It doesn't make any sense. Whereas in Latin America, it was different. You didn't have that same problem as you've had in Africa. And I don't think that uti possidetis should be seen as a rule of use, cogens, or as an automatic rule. Thank you.
I regret being in the obligation of stopping you, but I have to do it. Just in passing, without intruding in a legal discussion that I cannot handle, even though I tried to read a little bit in international law. The current Republic of Armenia, over the past 20 years, has been at least twice on record as not contesting the Treaty of Kars. The last one was the Foreign Minister Oskanian who stated that. It's just in passing as a student of history, political science.
Well, I don't think anyway. It would be maybe too long to enter in a discussion about US cogens. But I don't think anyway it would concern the boundaries. I could follow you on the genocide. On the genocide part, but maybe it will be for this afternoon to discuss more the genocide part. But for that, you must recognize at the international level that there was a genocide, which is not the case for the time being. Some states in their international domain, at the domestic level, have done so, for instance, France. But at the international level, I am not aware of an international recognition of an Armenian genocide. And even the Treaty of Sèvres mentions crimes of war, massacres, which is different from the concept of genocide, which is a new concept emerging after the Second World War. So it would mean legal construction, which could be possible, but which had to be made and to be accepted by the international community. I admit that there is a way, there is a room, but you must follow on that, and it's not established for the time being. And on uti possidetis, whether it's a good political principle is one thing, but in my view, it remains, it is more than ever a legal principle. At some stage, International Court of Justice was referring to it, but not as a legal principle. Now, International Court of Justice is mentioning it as a legal principle. So there is more a growth of force of this principle in the current law.
First, thank you for pointing out another important aspect of the Treaty of Seven, that is the Turkish acknowledgement of a free and independent Armenia, getting back to an earlier question. Picking up on something that Professor Zayas mentioned, and that is the first conclusion that you reached about the Armenian state having the authority to act under the umbrella of Soviet law. That's a question of Soviet law, right? And your conclusion is based on the fact that other Soviet states have been able to do this. Yeah. Is there any? I think that may have occurred later, though. Was there at the time of 1921? Was that clearly established? I would imagine getting a legal opinion on that would also be pretty important to this as a matter of Soviet law.
Anyway, what is important is that Russia and Turkey were recognizing the international capacity of Armenia, Azerbaijan, and Georgia to sign international treaties. Yeah. It is that what is important. Whatever their statute, whatever they were recognized as states or international subjects, with even not having the legal statute of independent states. You have for instance, look at the principle of peace between Israel and PLO, it doesn't mean that you recognize a state, but you recognize an international capacity, which is important.
If I may, just again as a historian, but it might be an issue that has relevance legally. One aspect of this problem, for somebody like me at least, is that much of the Treaty of Kars was already signed between the Bolsheviks, Russian Bolsheviks, and the Kemalist movement in the Treaty of Moscow, which preceded it by many months. So the autonomy or independence of the Treaty of Kars is quite questionable. I mean, it's like a copy, imposed on the Caucasian republics, with the Armenian party being the main loser, and Georgia being a much smaller loser in this deal. So I was wondering whether that fact that has any meaning insofar as international law is concerned.
I don't think so. Except if you can put in jeopardy the consent of Armenia. That's the matter of the consent of Armenia. If Armenia consents, okay. Coactus voluit, sed voluit.
We are going to take 2 or 3 questions, and then we'll have a break up to 2 p.m. to have lunch. Thanks so much. Questions, not lengthy comments.
Thank you, Professor Sur, for the detailed analysis of the Kars Treaty. But if I understood you correctly, you mentioned as an example that the Soviet Union recognized the right of Belarus and Ukraine to sign treaties. Did I understand you correctly? But I do not believe that the other republics had that capacity, because when let's say the victorious powers were negotiating the creation of the United Nations, the Soviet Union requested that the US have 48 representatives, for 1 representative for each state in the new General Assembly, and that the Soviet Union should have 16 representatives. At that time, there were 16 republics. Afterwards, it was reduced to 15 because the Karelo-Finnish Republic was cancelled. The US insisted that they will have 1 representation. It will be the US, not at the state level, but at the federal level. And that the Soviet Union will have, as a Soviet Union, a representative, and that Belarus and Ukraine, because of their sufferings during the war, they will participate in the creation of the United Nations, and Ukraine and Belarus have signed, adhered. They were founding members of the United Nations. They were one of the 2 of the 50 member states that signed in San Francisco the Charter of the United Nations. So by that, already the Soviet Union recognized officially that none of the other republics can have international treaties or agreements, except the Soviet Union per se, speaking on the entire Union, on behalf of the entire Union, plus the Ukraine, plus Belarus, which were recognized by the international community, rightly or wrongly, as independent sovereign states. Now, in 1920 or 21, these republics did not exist. Particularly Armenia, Georgia, and Azerbaijan did not exist as independent republics. They were still, at that time, if my historical memory is correct, the committee of the Caucasus, of the Communist Party of the Caucasus, or whatever it was called at that time, I forgot now the right name. Huh? They were not sovereign. So, they were not yet recognized as republics, because the Soviet constitution establishing these republics came much later, in the 20s, in the 28, I think, 23, yeah. So at that time they weren't. My question is, why is if what you are saying in this respect, we should follow that line. If we are going to respect that, why is Turkey insisting continuously, and they had it included in the protocols which were not ratified, insisting that Armenia recognizes the borders? It's still a question pending between Turkey and Armenia. Turkey is still insisting that Armenia should recognize the borders, and it was put in the protocols. There are declarations by the Minister of Foreign Affairs, by the government, but Turkey apparently is not yet so sure that something is not fishy in that treaty. It's a question. How do you explain that?
Also, and then you give the definitive answer. This question is, crucial. There is an indication that I would like to add, again, as a student of history and following the politics of the region and teaching it, that may be relevant to this issue. In a moment of enthusiasm, the former Turkish ambassador to Washington, Mr. Shukri Elekdar, who went on to hold very high position in the foreign ministry of Turkey, stated that actually what is of interest to us in the Treaty of Kars is not Article 14 or 15, which basically cancels any culpability about crimes committed during the Caucasian War. An article which can be expanded, okay, to include the Armenian genocide, among other things. So I am wondering whether the real issue is really the boundaries, or through the ratification of Kars to go to the weaker point of point, which is the genocide. That was the marginal comment.
Okay, let's begin with that. We come back to the point of Professor de Zayas. Article 15 claims that there will be an amnesty for all the crimes committed during the war on the Caucasus front. So that could be at stake. If you admit that there is a jus cogens norm, supervenience, jus cogens, that could not invalid but terminate that clause. Terminate. But the border is an entirely different matter. You were referring to Ukraine and Belarus. Okay, but... No. I was referring, and okay. If you read Stettinius, you know he was the Secretary of State of Roosevelt, and he had a kind of procès-verbal of Yalta. The discussion was about the underrepresentation of Soviet Union. You Western countries, you are numerous, and we are alone. So it was agreed to give them 3 votes. That was the main reason. Whatever. Was Armenia a state during this period? Only states have boundaries. Only states have boundaries. You have no other entities that state having boundaries, and Kars treaties dealing with boundaries. So it's an implicit recognition of the status of state of Armenia. And whatever the recognizance by other states, Kars Treaty established its own legality, meaning that the parties recognize each other as states. Each other. Other states are not bound to recognize that, but between the parties, it's binding. So for Turkey, Armenia is a state with boundaries. For Armenia, Turkey is a state with boundaries. As far as protocols of 2009 is concerned, yes, I think you are right. Your observation is perfectly justified. But even about the borders, recall the matter of otherness, border, eastern frontier for Germany. When the reunification arose, Okay. When the reunification arose, Western countries were very keen to get a reaffirmation, a reassessment of the acceptance of the Oder-Neisse border by Germany. It was not legally necessary, because as far as it was a reunification process, the state successor, Germany, was accepting the territory of East Germany as it was standing. So, Oder-Neisse. And you had already an agreement about the Oder-Neisse frontier with Poland. So that was not a legal question at all, but politically it was sensitive. And I guess it was the same in the protocols.
I had one comment, again, not from the perspective of an international lawyer, which I am not. The Treaty of Kars, you know, in our discussion about the Treaty of Sèvres, there is a point in the Treaty of Kars that newly Sovietized Armenia signed, which considers as null and void any treaties that Armenia, in particular, has signed, you know, with Western powers and others. That's right, Article 1. So it can be easily argued, if you question Sèvres, that, you know, you signed the Treaty of Kars, saying you are considering all the previous treaties signed without our agreement, you know, as essentially irrelevant. You know, we can read that first article, maybe, just for the fun of it, you know. It's in French. So the governments of the Great National Assembly of Turkey and the governments of the Socialist Soviet Republics of Armenia, Azerbaijan, and Georgia consider as null and void treaties concluded between the governments which have exerted power previously on the territories pertaining to this treaty and so on. I mean, I won't translate the whole thing. I need to take a little bit more time. But basically, the Treaty of Sèvres is included in this article number 1. Very clearly. There is no doubt about it. You know? We'll take one more question, and then we need to take a break because time.
Anyway, it was not in force.
Yeah. In addition, yes, the fact it was irrelevant. A question, please, sir.
Thank you. Professor Sur, my question is concerns the issue of capacity, the capacity of Armenia to have entered the Treaty of Kars or to be bound by it. You started your analysis and you focused a great deal of attention on the fact that Armenian representatives took part in the process. You focused on provisions within the treaty itself as evidence of why Armenia should be, in your opinion, should be bound by it. I just wanted to put out sort of a question of more general legal principles, not necessarily international legal principles per se, but of capacity of someone, of an individual to have the capacity to enter a contract, or in this case, of a nation or a state to enter a treaty. Shouldn't the political circumstances that surrounded the times, the pressures that Armenia and Armenian representatives were under, be factored in to a determination whether, in fact, Armenia had the capacity to enter that treaty, and whether, in fact, it should be held in force?
Yes, but you are referring to a fundamental change of circumstances. And you find the reply, the answer in Article 62 of the Vienna Convention. A fundamental change of circumstances may not be invoked as a ground for terminating or withdrawing from a treaty. So the matter of boundaries is excluded from the scope of fundamental change of circumstance or rebus extantibus.
And so we are going to have a fundamental change of circumstances, and we are